So for week 9 of legal reasoning, this video is going to be about what we've read this week and last week, and just a little bit about what we learned. So this dives a little more into again, how we structure our legal reasoning and how we build an argument. I think we all know that like everything begins with the facts of the case. We cannot like start making our argument until we like know everything and question everything, just like we talked about in class. It's especially with like the cognitive bias, like we got to be able to sort out like what is real and how we can take those facts and turn that into an argument. Facts help lawyers find the law, and facts also help lawyers apply the law to the specific situation. So now we bring into evidence and what counts as evidence. So in a trial, facts that we have already gathered now have to be proven by evidence. This is like the grounding in the syllogism model. There's two main types. There's oral testimony, which is calling in a witness and getting their testimony, them telling us either, their expertise, what they saw, etc. Then we have physical evidence, things like documents, photos, objects. This would be anything left at a crime scene, any video recording from cameras, maybe the broken mailbox on the way out, things that can be shown in court. It's not the he said, she said, it's objectively the physical evidence. Not everything can be used in court. So for evidence to be allowed, it has to be relevant, meaning it has to help prove or disprove something important in the case. It can't be something irrelevant. The witness also has to explain how they know what they're talking about. So, did you see it? Do you know this person? Are you an expert in whatever like field this is? Why is it relevant that we're listening to your thoughts and opinions? Sometimes evidence can get excluded entirely. Hearsay, which he said, she said, evidence could be unfairly prejudiced to the jury, and there could be other like courtroom policy-based reasons, but truth in the court can be filtered in a sense. So as I've said, evidence is not the same thing as a fact. It's just what's presented in court. The fact is what the jury or the judge or whoever's determining the facts of the case, that's what they determine based off of the evidence, or based off of, what point of view you're trying to get them to believe. Once facts are established, lawyers can apply those facts to the law, creating a rule. So this determines people's rights and responsibilities. Law itself is made of rules and policies behind those rules. There's two main ways that lawyers typically apply these rules. First is deduction. So this is a strict logical approach. You ask yourself, do the facts fit the rule exactly? If yes, then the rule applies. If not, then it doesn't. The second is analogy. This is a little more flexible, but it's less convincing. You ask, are the facts similar enough to another case? If they are, the rule might still apply. Sometimes things become unclear whether facts fit the rule or if the situation is just similar enough. This might lead to a little bit of uncertainty, and that's when lawyers turn to policy-based reasoning. Instead of asking, what does this rule say, they say, what outcome makes the most sense, what achieves the purpose of law. This involves weighing values, goals, and consequences. So the debate is, should judges focus on rules first, or should they focus on the best outcome? It's kind of, what are we hoping to get from this case? What precedent do we want to set? Sometimes, like, because we have a common law system, it might not make a lot of sense why judges choose certain rules, but they're thinking about how it could be applied in other situations or other contexts.